Commercial law is also known as mercantile law or trade law. It is a body of law that governs business and commercial transactions. It is often considered to be a branch of civil law and deals with issues of both private law and public law. It is also called as business law. There are too many branches of commercial law, such as companies law, corporate law, corporate governance, competition law or antitrust, consumer protection, contract law, environmental law, intellectual property law, copyright law, patent law, trademark law, international trade law, labor law, and insurance law. Example of related to commercial law is the electronic commerce or what we call e-commerce. It is the activity of electronically buying or selling products on online services or over the internet.
Now let us define what is Corporation Code. The Corporation Code of the Philippines Batas Pambansa Bilang 68, which was approved and became effective on May 1, 1980, is the law that governs rules and regulations in the establishment and the operation of stock and non-stock corporations in the Philippines. The code consists of 149 sections that are grouped into 16 cities. The code gives the legal definition of a corporation. It also clarifies the basic classifications of corporation, which can be stock or non-stock corporation. The code also discusses the classifications of shares in stock corporations like common stock and preferred stocks. Lastly, the Corporation Code of the Philippines also covers the basic powers and capacity of corporation. It also discusses the powers of corporation to extend or shorten corporate term, to increase or decrease capital stock, to declare dividends and other honors given by the code.
A corporation is a legal entity created by individuals, stockholders, or shareholders, with the purpose of operating for a profit. Corporations are allowed to enter into contracts, sue and be sued, own assets, remit federal and state taxes, and borrow money from financial institutions. The creation of corporations involves a legal process called incorporations, where legal documents containing the primary purpose of the business, name and locations, and the numbers of shares and types of stock issues are drafted. The process of incorporations gives the business entity a distinct feature that protects its owner from being personally liable in the event of a lawsuit or a legal claim. A corporation can be created by a single shareholder or by multiple shareholders who come together to pursue a common goal. A corporate can be formed as a for-profit or a not-for-profit entity. For-profit entities, from the majority of corporations, they are formed to generate revenues and private are returned to their shareholders, according to their percentage of ownership in the corporation. For the no-for-profit, it's operate under the category of charitable organizations which are dedicated to a particular social cause such as educational, religious, scientific, or research purpose, rather than distribute revenues to shareholders. For the no-for-profit, organizations use their revenues to further their objectives.
A corporation is a separate legal entity from its owners, offering liability protection for each owner's assets. Corporations can generally conduct any lawful business as well as action necessary to conduct the business, like entering into contracts, owning assets, borrowing money, hiring employees, suing, and being sued. A corporation is required to name a board of directors before it can commence operations, and then members of the board of directors are elected by shareholders during the annual general meeting. Each shareholder is entitled to one vote per share, and they are not required to take part in the day-to-day running of the corporation. However, shareholders are eligible to be elected as members of the board of directors or executive officers of the corporation. The board of directors comprises a group of individuals who are elected to represent stakeholders. They are tasked with making decisions on major issues affecting the shareholders, and they also create policies to guide the management in the daily operations of the corporation. The elected members of the board of directors owe a duty to care to the shareholders, and they must act in the best interest of the shareholders and the corporation. The precise legal definition of corporation differs from jurisdiction to jurisdiction, but the corporation's most important characteristic is always limited liability. This means that shareholders may take part in the profits through dividends and stock appreciation but are not personally liable for the company's debts.
So today guys, I'll discuss about how corporation may be dissolved. So a corporation may be dissolved by the SEC or upon filing of a verified compliant by any other interested party. The following may be grounds for dissolutions of the corporation. The first one is non-use of corporate charter. The second one is continuous in operation of corporation. The third one is upon receipt of a lawful court order dissolving the corporation. The fourth one is upon finding by final judgment that the corporation procured its corporation through fraud. And the last one is upon finding by the final judgment that the corporation was created for the purpose of committing, concealing, or aiding the commission of securities violation, smugglings, tax, evasion, money laundering, or graft and corrupted practices. If the corporation is ordered dissolved by the final judgment pursuant to the ground set forth in subparagraph above, its asset after payment of its liabilities shall, upon petition of the SEC with the appropriate court, be forfeited in favor of the national government. The SEC shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the involuntary dissolution of the companies under their special regulatory jurisdiction.
A partnership is an agreement between two parties known as the business partners to work together for further their joint goals. Individuals, businesses, interest-based organizations, schools, governments, and combination of this can be partners in a partnership. Partnerships expands your knowledge, expertise, and resources, allowing you to create better goods and reach larger audience. There are numerous forms of partnerships recognized by the federal government.
How is partnership created? A partnership is a business form created automatically when two or more persons engage in a business enterprise for profit. Consider the following language from the Uniform Partnership Act. The association of two or more persons to carry on as co-owners of a business for profit forms a partnership, whether or not the persons intend to form a partnership. A partnership in its various forms offers its multiple owners flexibility and relative simplicity of organization and operation. In limited partnerships and limited liability for partnerships, a partnership can even offer a degree of liability protection. Partnership can be formed a handshake, and often they are. In fact, partnerships are the only business entities that can be formed by oral agreement. Of course, as with any important legal relationship, oral agreements often lead to misstood or misunderstandings, which often lead to disputes. Thus, you should only form a partnership that is memorialized with a written partnership agreement. Preferably, you should prepare this document with the assistance of an attorney. General partnerships, limited partnerships, and joint ventures all offer ways for businesses and businesses owners to work together for a common goal, but they have distinct character and characteristics that need to be considered. An experiment and knowledgeable business law attorney can help you determine which business form is in your best interest.
Partnerships can be formed as either general or limited partnerships. In a general partnership, the operations of the business are controlled by one or more general partners with unlimited liability. The partners co-own the assets and share the profits. Each partner is individually liable for all debts and contracts of the partnership. In a limited partnership, the limited partners are financial partners whose liability is limited to their investment. They do not participate in the firm's operations. The advantages of partnerships include ease of formation, availability of capital, diversity of managerial skills and expertise, flexibility to respond to changing business conditions, no special taxes, and relative freedom from government control. These advantages include unlimited liability for general partners, potential for conflict between partners, sharing of profits, and difficulty exiting or dissolving the partnership.
Chapter 3, Article 1828 of the Civil Code of the Philippines is all about the dissolution of a partnership is the change in the relation of the parties caused by any partner ceasing to be associated in the carrying on of the business. Here are the causes of partnership dissolution. Number 1. Without violation of the agreement between two partners. Number 2. In contravention of the agreement between the partners where the circumstances do not permit a dissolution under any other provision of this article by the express will of any partner at any time. Number 3. By any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Number 4. When a specific thing which a partner has promised to contribute to the partnership perishes before the delivery, in any case by the loss of the thing, when the partner who contributed it, having reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Number 5. By the death of any partner. Number 6. By the insolvency of any partner or of the partnership. Number 7. By the civil interdiction of any partner. And lastly, by decree of court under the following article.
Here are some corporations that are related to tourism and has partnerships. Discovery Hospitality is an exclusive partner of Discovery Fleet, a deluxe cruise for divers and non-divers alike, introducing a new style of cruising through the Philippine Islands. Travelers are welcome on board the 20-room MV Discovery Palawan, refitted with a powerful engine and modern navigational equipment in 2016. It moved to the Philippines as an adventure cruise ship. In its effort to help boost tourism and economic recovery in Cebu, in June 2021, AirAsia Inc., a partnership with Hotel Resort and Restaurant Association of Cebu Incorporated, as its official corporate airline partner. This partnership is aimed at promoting safe domestic travel in Cebu, which continues to thrive through its self-sustaining tourism industry. HRRACI is a non-profit, non-government organization that provides an avenue for strategic partnerships among its member, company, associates, schools, and other stakeholders with the common goal of promoting Cebu as a world-class tourist destination.
What is insurance? Insurance is contract represented by a policy in which an individual or entity receives financial protection or reimbursement against losses from an insurance company. Insurance giving an employee to be safe if they have this. Whatever happens to them, they are comfortable that they have an insurance. The insurance is one way to protect your life even though your health. And also, insurance is key to you being able to focus on the important things in life because it will ensure financial security for you and your family should anything unfortunate happen. Who can have insurable interest? Insurable interest, it means that someone would experience financial hardship upon your death. The person who is purchasing the policy needs to have an insurable interest in the insured person. Like examples, the employees in the company, they can have insurable interest, or the spouse who relies on their partner for finances has an insurable interest.
Commercial laws play a vital role in regulating business practices in a country. It is important that business owners and entrepreneurs know what business laws are applicable to their types of businesses and activities. These laws and rules should be followed to avoid punishments, charges, and penalties from the government or authorities that are implementing and enforcing them. Some of these laws are not only created to obligate business owners to do their duties, but they are also made to obligate the government to protect these business owners, to make sure you are doing business legally, and to know the degrees that give your business protection and privileges. Thus, commercial law is of supreme importance for smooth, fair, and profitable conduct of businesses in every sector of commerce and economy.